everybody, and welcome to our 2026 case law update. I am Yvonne Guibert. I'm co-host of the Deconstructing Comp podcast, and I'm so excited to bring this educational session to you today. Today, we're just doing a quick preview of what's to come. We have rescheduled our full case law update to June 6th. So hopefully you'll get that notification soon. I'll get that email out to everybody. So I would like to turn this over to David Pollock to introduce our panel and get started. Hi, David.
Hi. Nice Saturday morning for all of us. Let's see if I can get the PowerPoint up. Let's see, sharing. Not letting me do it. Share. There we go. Alrighty. Let's just pause for a second to see this awesome animation. All right, so the perfunctory disclaimer. The materials and opinions expressed in this presentation are the opinions of panelists and do not represent the positions of either the Department of Industrial Relations, the Department of Workers' Compensation, or the Workers' Compensation Appeals Board, with the exception of Frank Christine, where his opinions ought to be those of the Department of Industrial Relations, the Department of Workers' Compensation, or the Workers' Compensation Appeals Board.
Thank you for that, David.
All right, you guys. I figure we should just do an hour and then just go home early, okay?
I like that. Wait a minute, I thought we were doing 5 hours today. I prepared for 5 hours. I did too.
Oh, come on, you guys.
Bait and switch.
I don't want to go 5 hours. Let's just do an hour.
Okay.
All right. So we've got the med legal procedure. On-bank decision. Why don't we just start with that? Because why not? So the Vasquez versus in Coasio Renteria, an on-bank decision, which means it's binding on everybody, so you ought to know it. Let's drive through the facts on this case. So the applicant is represented by counsel, filed a petition for removal of the findings and order issued on March 11, 2025, where the WCJ replaced a QME pursuant to Administrative Director Rule 31.3 and 31.5 because the QME wasn't available to reset an evaluation within 120 days. So this is a major problem that we run into. You call the doctor's office, can I get a timely appointment? Hell no. So applicant argues that the time limit set in Rule 31.3 should not be enforced to compel the replacement of a QME is not available. Instead, applicant cites to a prior panel decision and argues the WCJ should have applied a balancing test as opposed to just an automatic reset in deciding whether good cause exists to warrant replacement of the QME. In an on-bank decision, the appeals board granted reconsideration, and as part of their decision, they put together two main bullet points. One is that only the appeals board has jurisdiction to determine whether a replacement panel is valid or otherwise appropriate. That's important because the medical unit is not there to determine whether or not replacement QMEs are an appropriate remedy. Two, in a represented case where a QME doesn't establish an availability within the time frame, the appeals board does have the discretion to order a replacement QME panel, but they have to consider the length of the delay. Close this. Try that again. Share. Share, and it's not doing what I want it to do. Share. Is it not doing what I want it to do? There we go. In a represented case, okay, so it's the length of the delay caused by the QME's availability and the amount of prejudice caused by the delay in availability versus the amount of prejudice. So we're doing an analysis and see what efforts, if any, have been made to remedy the availability, case-specific factual reasons that justify replacing, or the appeals board's constitutional mandate to accomplish substantial justice, which the big problem is if you keep replacing doctors, it creates all these inherent delays. So it's a B, C, D, and E application to it. So in this case, so let's delve into the facts. So the applicant was reported as a seasonal agricultural worker on March 17, 2017, when he sustained an industrial injury to his left ankle and left calf, and claims to have sustained injury to various internal body parts. Ira Fishman was selected as a QME to evaluate the compensability of applicant's internal complaints and issued 2 reports. Dr. Fishman initially evaluated applicant on May 21st, 2021. On May 31st, 2022, he issued a supplemental report. So we're talking about a case where Dr. Fishman has issued several medical reports in the past. And when the applicant attempted to request a reevaluation, the next available date was 127 days later. On August 5th, 2024, defendant requested a replacement QME panel because the reevaluation was scheduled more than 120 days. Applicant obviously objected because this is going to drag this case out. We're doing a do-over and we're throwing out all of Ira Fishman's reports. There's prejudice there somewhere. On August 15, 2024, applicant objected, arguing the time limits only apply to initial evaluations and not to subsequent evaluation. Defendant responded by applicant's letter and arguing the time frames apply to both initial and subsequent. So you can tell what's going on in this case. There's a lot of gamesmanship going on. The defendant probably didn't like Ira Fishman's medical opinions and wants to do a do-over. The DWC miraculously issued a replacement panel. Applicant obviously objected, and the issue of whether or not the replacement QME panel was appropriate was set for trial. So the rule here is that only appeals board has the jurisdiction to determine whether a replacement QME panel is appropriate. And in a represented case where a QME does not establish availability within the time frame, we do have discretion to order a replacement QME panel for good cause. Here, the WCJ is finding the QME should have been replaced because it was outside the 120 days. So we're talking about 127 days here, so 7 days outside of the time frame. Thus, our discussion is focused on whether or not the statutory language allows for replacement under these circumstances. As explained below, when we aggregate the labor code sections, the party's statutory right to seek replacement arises when the QME fails to timely issue a report following a medical evaluation. In a represented case, the determination of whether or not a QME should be replaced due to unavailability to set an evaluation is within the discretionary power of the appeals board. Our decision here clarifies the factors. We do not seek to create a landslide of litigation. As noted above, the time frame suggested in the regulations may be considered by the WCJ. Thus, we conclude that it's appropriate to apply this interpretation prospectively. So it's getting sent back. So, Judge Rask, it's 127 days. Ira Fishman has already issued several reports already. The defendant just doesn't like what Dr. Fishman is trying to say here. Why, and it's a subsequent evaluation. Why are we going through all this nonsense?
Because the politics of it is such that the appeals board does not want the medical unit to make determinations of replacements or additional QME panels. It is as simple as that. This is part of what I like to call the panel wars, and this is a continuation of the panel wars. And the theme of panel wars all the way across the board, since all of this started years ago, is the friction between the appeals board and the WCJs versus the medical unit. And sometimes the medical unit has tried to be more aggressive in intervening into what should be a judicial function and to make determinations based on the regulations that pertain to the QME process. To either replace a QME or to grant an additional QME panel. So I think this AmBank decision is just a response by the appeals board, drawing the line in the sand of the jurisdiction between the appeals board and the trial judges and the medical unit. And they're telling the medical unit, hands off on these disputes, let the judges decide them.
All right, but Frank, the issue that Judge Rask hadn't really addressed is this multifactorial analysis to determine the prejudicial effect behind it, and just the bare facts of this case don't seem to bear out on it. So, I mean, do the defendants really have a genuine issue here, or is it just Dr. Fishman wrote a report? I don't like his report. We're scheduling it. It's 7 days outside of the time frame, so we want to do over. Get a new doctor who's going to just that's going to break towards us. I mean, is there a legitimate defense argument here to be made?
Absolutely. And let me tell you why. The date of the injury in this case was 5 years before Dr. Fishman started reporting in the case on an internal case that arises from physical injuries. So the case starts out typically as an orthopedic case, and there are requests, there are applications for adjudication of claim that are amended and body parts are added. So by definition, the case is expanded exponentially years and years into the future. And it's difficult to budget financially when you have ongoing litigation, ongoing body parts. And the doctor basically said, well, I'm not going to comply. I'll give you a date just outside of the 120 days. And the defendant got fed up and said, enough already. We've already spent all this money. We're not getting the opinions that we need to get. we're going to go to the only process that we know to get a replacement panel, and that's the medical unit.
And they don't care about the do-over aspect of it.
Well, I think at this point, the doctor, at some point, the doctor's office can get you an exam within 120 days. So this is a fight between the doctor and the scheduling law firm. Simple as it is, they could have easily gotten the examination within 120 days. They just chose not to. And I think in this case, the defendant rightly went to the medical unit. Now, here's the problem. Once the defendant gets to the trial judge and the trial judge says, "Oh, I'm going to weigh all these factors," then at that point, then the defendant has to say, "Are we going to reinvest in a new doctor, or are we going to make a point?" And that is, Dr. Fishman and your office cooperate with us.
So when I had a case similar to this come up way before all this came up, I just took the position that if it's a subsequent evaluation, it's outside the statutory time limit, it's supplemental reporting, I don't care. There's just inherent prejudice in all of those things.
Well, what I do in my courtroom, and I encourage my judges to do that, is first of all, defendants should file an expedited hearing on this issue. And we will hold everyone's feet to the fire, and you will call the doctor's office from my courtroom and say, "The judge is standing here telling me to call you to get a date that's within 120 days.
That's right.
And virtually every single time we've done that, we've gotten a date earlier for
Yeah.
a depot, for a reexamination, whatever it is. This case is totally unnecessary.
Yeah.
And I'll just end this discussion by saying, in every one of these situations, when you press the parties who are enough, they basically say, "I just didn't like the QME's opinion." It's not substantial medical evidence.
Well, if they didn't like the PQME's opinion, they wouldn't have gone this far. But like I said, the doctor's office was playing games. They could have gotten that exam set within 120 days. They knew about it, right? So, yeah.
I get it.
Yeah.
Next case is Martinez versus H&H Wallboard Incorporated. Applicant seeks removal of the findings and order issued by the WCJ, wherein WCJ found that in pertinent parts of the reporting of QME, Lorenzo Hughes violated 4628, that the reporting doesn't constitute substantial medical evidence, and that must be stricken from the record. Very pugilistic parties here, constantly striking people all the time. WCJ also granted defendant's petition for replacement QME panel. Applicant contends that Dr. Hughes did not violate section 4628, and that the delays associated with applicant having to be reevaluated by new QME will cause irreparable harm to the applicant. Defendant has failed to establish valid basis for the replacement. After considering the petition for removal, they're granting the petition for reconsideration and returning the matter back. So rescind and remand. Facts of this case: applicant Manuel Garola Martinez sustained an admitted injury to the right wrist, right shoulder, and right forearm, and alleged injury to other body parts while he was working for H&H Wallboard. The doctor had issued numerous reports and had his depot taken. So after the deposition, defendant filed a petition for replacement seeking to replace him, asserting that 4628 was violated by allowing a third party to summarize the medical records. So we're going to start getting into third parties, artificial intelligence, large language models, all that fun stuff. Defendant filed a DOR for expedited hearing. The issue was submitted for decision. Both parties filed post-trial briefs. Section 4628 imposes penalties for non-compliance. Substantive Division E states that failure to comply with the requirements of 4628 shall make the report inadmissible, shall eliminate any liability for payment. So we get into these issues about if something's not substantial medical evidence, is it stricken? Is it subject to being stricken? The other problem is if the doctor doesn't even meet the minimum requirements necessary for the proper composition of a QME report, that would be the basis upon which to strike the report, render it inadmissible. Subdivisions F, G, and H address additional penalties for physicians knowingly failing to comply with the requirements. They could be held in contempt if that's possible, and the possibility the physician will be terminated, suspended, or placed on probation. Thus, finding a physician has not met the minimum report preparation and disclosure standards may result in significant consequences. Well, gosh, don't you think there's a due process problem there? I do. Here, the due process rights of Dr. Hughes were implicated in WCJ's finding that Section 4628 was violated. Dr. Hughes' medical legal reporting didn't constitute substantial medical evidence, resulting in his reports being stricken. Dr. Hughes won't be compensated, including the preparation of the 6 medical legal reports. Dr. Hughes has now become a party to interest and a potential lien claimant. And gosh darn it, I mean, if you're going to strike his report and say it's not substantial medical evidence, that could actually affect his credentialing with the medical unit. Yet there's no evidence in the record that he'd been provided with a notice that a determination of 4628 would be made, nor was he provided an opportunity to be heard. Therefore, he has an obligation. He needs to be given an opportunity to actually appear in court and defend on this case. So, as I indicated before, after reviewing the available evidentiary record in this matter and for the reasons stated forth in the WCJ's opinion, it is very likely the WCJ correctly determined that Dr. Hughes' medical legal reporting violates 4628 and his reports should be stricken. Despite this, we cannot affirm the F&O. His due process requires the QME be provided with notice and opportunity to be heard. So we think he probably should be found culpable, but we won't actually render an adjudication on it. So we're going to grant the petition, rescind it, and remand it, and give the doctor notice and opportunity to be heard regarding the petition for replacement. I doubt that the doctor may actually appear on this one. Judge Rast, the issue that comes up here, I guess, is do we really want QMEs having to come down to court to have to represent every time one judge just happens to find it's not substantial medical evidence?
Well, I think the issue is bigger than that. This doctor utilized Doctus, which is an outside vendor, to do the medical reporting review of and summary of medical records. That's by itself is very disturbing. You have to read 106.82, 35.5, and section 139.3 of the Labor Code together to put together what elements have to be in a medical legal report and the ethical considerations for that. Doctus is an AI company, and that issue has not been litigated yet in the context of this case. But it is a trend that is occurring now where the regulations in the statute require all medical legal doctors to state under penalty of perjury who assisted them in the preparation of their reports. That includes the summary of medical records, and that they would go over pertinent medical records with the injured worker at the time of the evaluation. That seems to have not occurred in this case, and that's what he testified to in his deposition. When he was asked in his deposition, who from Doctus reviewed your medical records that were sent to them, his answer was, I don't know. And when you go to their website, it's a pure AI program that does the summaries. And so a lot of doctors are using AI commercially available products that they pay for to do these summaries. And there seems to be a lack of review that is the responsibility of the QME. And that's where the anti-ghostwriting statute 4628 comes into play.
All right, well, Frank, I mean, is this really such a huge issue, this idea of third parties handling it? I mean, the easy solution to this is just bringing the software in-house and just have somebody working for the doctor doing it.
You know,
I mean, what is having a large language model simply aggregate 20,000 pages worth of documents into a quick summary, stick it to the top of the pack, and just have the doctor review it?
that's a good point. But the defense community expects that if the board is going to scrutinize every word of these medical legal reports on the basis of substantial medical evidence, and most of the applicants' attorneys are fighting us on the detail in our initial letters, making review of the medicals a treasure hunt so that the doctors are going to have to try to figure out what the controversy is. And our letters are not very specific regarding the controversy because the applicants' attorneys are objecting. At $3 a page, you expect the doctors to review the medical reports line by line, word by word, so that the reports are substantial evidence. Now, if the doctor doesn't get an initial report out within 30 days, what happens? Right? Either side can object to the report, and there's no avenue for due process. There's no avenue to go to the board and say, oh, gee, my secretary got sick. I couldn't get my report out. Why is 4628 in this case an avenue for the doctor to come down to court and have quote unquote due process of law and explain why he used AI to get through the reports? I don't think it's consistent. I don't like the decision. It's costing the defendant a lot of money. At $3 a page, you expect that doctor is going to be billing for reporting that they reviewed.
I mean, I just think a lot of this. I think a lot of this debate just seems rather off the point. You could resolve the issue of having a third party reviewing all this stuff by just simply bringing it in. So the doctor simply has the software embedded on his computer itself. You just have it all read by them. I think the real debate would come in if the summary, which is actually provided, starts to hallucinate in some way.
Well,
then it would start creating a problem.
We don't know
there yet.
We don't know their business model, right? We just expect that at $3 a page, the doctor is going to be reviewing and writing a report that is substantial medical evidence. So like Judge Rass said, under 106A2, those are the elements for a substantial report.
And so long as they disclose it in their report, I don't see what the problem is until it gets to the point where there's a demonstrable presentation of some form of hallucination that goes on.
Well, my point is that counsel from both sides need to review the records themselves.
That's right.
And, then they can make a determination of this. I think this is a due process case. It's more than that than anything else at this point.
Yeah.
So you want the doctors to come down to court?
Sure. Have at it.
I think they can come down to court on a lien.
Well, I think what these doctors ought to do, and the party should do the same thing, is like it's a tool, it's a supportive tool, it provides a summary, you still need to review the documents. It's just, I think there are a lot of Luddites in the system, unfortunately.
Well, somebody knew that there was a problem. That's the reason that it was revealed at a deposition, that the doctor did not review the records. There was a problem, an inconsistency. The doctor's report suddenly wasn't substantial. And I think the defendant had every right to replace that doctor and get a new doctor.
So let's move on to the next case. So we're going to get into AOEC. Hashagian versus City of Foster City. Defendant City of Foster City seeks reconsideration of findings of fact. The WCJ found in pertinent part the applicant sustained a cumulative trauma injury to his left index finger, injury arising out of a course of employment while working with the defendant. Defendant contends the WCJ erred in finding the applicant sustained cumulative trauma to the left index finger, where the AME concluded that current symptoms were the expected progression of initial specific injury and not a separate cumulative trauma. So we're going to rescind and remand. Applicant filed an application for adjudication of claim alleging injury to the left hand and left index finger as a result of cumulative trauma while employed as a police officer for defendant. Applicant also alleged a specific injury. Applicant was evaluated by Leonard Gordon, MD, as the AME. In his supplemental report, he confirmed his prior opinion. He clarified the plate on the applicant's finger is causing irritation, resulting in inflammation and that adherence of the tendons, which is an ongoing problem resulting from the 2017 injury and flare-ups of this nature with ongoing use can be expected over time. He went on to state that I remain of the opinion that this is an exacerbation of the original problem and not a new injury or aggravation, and that treatment is needed for this in order to prevent further episodes of such symptoms. Use of the hand over time would cause such periods of symptoms and exacerbation with forceful gripping and manipulating, and with reasonable medical probability results from the plates and the adherence of the tendons. I've recognized it has been a considerable period of time and the patient has had symptoms on and off. He likely has a waxing and waning of symptoms increasing at this time with indication of further surgery because of these ongoing episodes. Okay, so this sort of nails down the issue of, is this a new injury or is this simply a flaring up of the old injury? And the doctor gets it wrong, unfortunately. Here, there's no medical opinion finding a CT injury, nor does it appear that Dr. Gordon may have a misunderstanding of it. In particular, Dr. Gordon does note the contribution of the ongoing use of the hand for nearly 5 years as a police officer in general use. As noted by the WCJ's testimony and reporting is contradictory at moments, but Dr. Gordon still concludes the current condition is a natural progression of the treatment for the original injury. As a result, the WCJ found the reporting not substantial. We too agree that the report is not substantial. This results in a lack of substantial medical evidence. We observe it as somewhat problematic to have a finding of cumulative injury without determining injurious exposure, periods of injurious exposure, or date of injury. Integral to the finding of a cumulative trauma injury is determine whether there's disability or need for medical treatment. Specifically in this case, there needs to be a discussion of whether or not there's new impairment or an increased need for medical treatment. As outlined above, we do not have enough evidence to support a baseline essential to determine new impairment or an increased need for medical treatment. In order to properly conclude there is cumulative injury, the medical evidence from the prior specific injury must also be considered. So, Judge Rass, I'm shocked that we have to explain to doctors what a new injury is versus an old injury. So if you could give us the single sentence of what is the difference between a new continuous trauma injury and an exacerbation of an old one.
Well, I think that the doctor actually articulates it here, but he just comes to the wrong conclusion. it's injurious exposure over time that results in lost time from work or any kind of disability. And you have that here just from the 5 years where the guy got worse. And police officers are constantly using their hands. In their training, they have to be able to use a firearm with both sides, both right and left, and dominant and non-dominant. And so he almost proves a CT just by his history in this case. But he misses a point in the difference between an exacerbation of an old injury and an aggravation of an old injury, which really is a higher level of impairment due to the additional injurious exposure in the 5 years since the original injury.
So Frank, I mean, these issues come up with public service employees all the time. They file a new application and it's like, come on, this is just something that happened 5, 6, 7 years ago. You're just filing this new app because you want to get more temporary disability. You're outside the 5 years. There's gamesmanship going on here. So what has been your experience in terms of trying to sort out the exacerbation versus aggravation argument?
Well, you hit the nail on the head, right? It's been beyond 5 years. 4664B says that, there is a conclusive presumption that the prior disability exists. The doctor says it's an exacerbation. He uses the magic word, right? Exacerbation versus aggravation. I'm going to take my case to the good Judge Rasp, and he's going to throw the report completely out.
I mean, I want another year of 4850 time.
Yes, that's right. That's exactly what was going on here. So, the doctor used the magic word. Whether or not there is a new CT and what's the date of injury under 5412, I think was the weakness in this case because it wasn't well defined. The doctor did use the magic word. He said that there was a reasonable probability that it related back to the initial injury because of the plate. So unlike some of the other cases where you have a new thing that's happening over the course of time, this related back to a specific injury. What can I say?
I think that everybody in the room and everybody who's listening should read Coulthard once a year because this is new injurious exposure.
Well, Western Growers in 1992. Western Growers.
That was a psych case.
Yes, it was a psych case, but it involved 5412 and a new CT.
Well, let's move on to an even more interesting case. These facts are going to blow your mind.
I'm still an applicant's attorney.
Well, of course you are.
You know that.
Yeah. The Thorne versus Forbix Capital Corp case. Applicant seeks reconsideration of findings of fact wherein the WCJ found that applicant did not suffer injury arising out in the course of employment based on the post-termination defense. And Labor Code Section 3208.2 subsection C, specifically determined whether or not a psychiatric injury is industrial related to being filed after the notice of termination. Applicant contends WCJ erred in finding that it was barred by 3600 on this one. No big surprise, rescind and remand.
Yeah.
On June 3rd, 2019, applicant filed an application adjudication, a claim alleging cumulative trauma, primarily psychiatric. Applicant claimed the psychiatric injury resulted from multiple instances of sexual harassment or discrimination because of gender identity. On March 2, 2020, applicant was seen by QME Dr. David Taylor, who authored one report. So this is where it gets the facts get kind of interesting from our perspective. He began his employment at Fox Capital Corp on June 11, 2018. His last day was on April 24, 2019. He worked as a receptionist. His job duties including answering phones, sorting mail, assisting clients, handling insurances for property and general clerical work. He was subject to sexual harassment. So what was the problem? He was criticized for his manner of dress being too effeminate. Both clients and coworkers made fun of his mannerisms and voice. He overheard his coworkers talking about his sexuality. As well, after he wore a dress to the company's Christmas party, the company's co-owner, Ron, lectured him, saying he should not have worn a dress, as he's not a woman. He became distraught and felt discriminated against. So Ron asked the patient, do you like me like that? Patient stated he was not comfortable with this conversation, told Ron he did not like it like that. He began to cry. HR representative told him he could not wear culotte pants at work. HR sent out an email specifying that men and women should be wearing. He felt discriminated. So pairing through these facts, I think the issue really comes down to, is there a good faith personnel action in place when an employer imposes some form of attire restrictions, or is this individual being persecuted, harassed for transgender type personality issues? Dr. Taylor diagnosed applicant with an adjustment disorder, the with the diagnosis date of April 24, 2019, the date of the applicant's termination, concluded the psychiatric injury was non-industrial, barred by 3208.3 subsection E because defendant did not have a pre-termination notice. Despite these allegations, applicant denied any impairment of performance of his duties, denied seeking treatment while employed. So the issue here really just comes down to post-termination, which is just not applicable here. Labor Code section 3208.3 specifically excludes compensation for post-termination claims, but the problem is it really doesn't apply to psychiatric cases. So it's really kind of ill fit here. So the WCJ in this, the applicant, while applicant has the burden of proving industrial causation for psychiatric injuries, defendant has the burden to establish a post-termination bar. Dates of injury are established under 5412. We don't need to go too much into the weeds on that one. We cannot apply 3208.3 subsection E without first knowing the date of applicant's alleged psychiatric injury. In other words, the date of the alleged injury is an essential component and it wasn't proven here. The WCJ also failed to properly apply the good faith personnel action. So WCJ didn't perform a role analysis. We have to go through the role analysis. What are the predominant causes of what are the predominant causes due to actual events, and is it substantially caused by good faith personnel actions? Didn't do it here. And the problem is nobody ever bothered to raise it, which is another problem. So it's not surprising that the parties did not present any specific argument or medical evidence on the issue, and it gets rescinded or remanded back. Judge Ress, there's not a lot we can cover on this one that I think is going to be particularly interesting beyond the bare facts itself. But I thought what was interesting about the case, though, was the dichotomy here between an employer's right to regulate what people wear on the job versus an allegation on the part of the injured worker that he was being sexually harassed in this case. So, I mean, where do you fall down on this sort of issue regarding, is it good faith personnel action or is it sexual harassment?
I would have referred this guy immediately to an employment lawyer. This is a bigger picture than workers' comp, number one, because I actually handled a case like this when I was in practice. And the civil attorney in the discrimination action got a hell of a lot more money for the plaintiff than they could have ever gotten in a workers' comp case. That being said, my takeaway on this case was that the judge failed in this case and should have applied the rule analysis. I think every judge has a duty to do that anytime a psychiatric claim is made. And that's the takeaway from the appeals board decision in this case. And it's a reminder of what's the date of injury for a cumulative trauma case. And that's when there's a concurrence of disability and knowledge. And that didn't occur here until he met with an attorney. And I remember trying a case in front of Judge Pollack on that very issue years ago.
Yeah, didn't you lose?
No, I won. Or you got reversed, one of the two. I don't remember which. But the point is that, I actually handled a case like this involving a cross-dresser. And that my client was harassed just as much as this one was. And we ended up winning the case in the workers' comp field and in the civil action.
So, Frank, I mean, if you were on this case, would you be telling the employer they messed up on this case and should have just let them wear a dress to work?
I don't think that's really the core question. The core question is whether or not Labor Code Section 3208.3E, which is a psychiatric post-termination statute, which doesn't have anything to do with the elements of discrimination or good faith personnel action or actual events of employment. Those are litigable issues under 3208.3H. The fact that the medical evidence that was submitted for decision didn't have rolled elements was what torpedoed the workers' compensation case. And we all know that there are actual events of employment that have to be predominant. And if you're relying on H, where 35 to 40% of the causation has to be due to a good faith and non-discriminatory personnel action, which is in the purview of the trier of fact. That was the issue here. They used 3600A10, which applies to physical injuries. And I think that was the mistake. Had they gone to a psychologist or a psychiatrist, I prefer a psychiatrist because the mental health, the mental defect, the mental, DSM issue, I think is a medical issue. He wouldn't have gone to an attorney if he didn't think he was hurt. He didn't think he was injured. And that to me is the date of injury prior to going to an attorney.
But
It's a factual issue.
I think for me, my focus seems to be on the non-discriminatory. I would have wanted to go through a fine detail as much as I could, exactly what this entire policy is. Is it applied to everyone? Is it applied to some individuals?
Right.
I mean, it wasn't done here.
That was a factual issue. Yeah.
And I need to know, he's characterizing it as harassment. I need to know exactly what was told to him.
Right.
If he's being told just wear pants to work and he wants to wear a skirt, I get it. He may think he is being discriminated against.
Right.
But if this is a policy that's being applied across the board, or if he's if some issue arises about transgender issues, I mean, I know where the facts seem to sort of lead towards, but the way I would look at it, I would really want to know, was this person genuinely being harassed, or is he just upset about a policy implemented by the company that is inherently embedded in the need to regulate what people have to wear to work?
And Judge Rass points out COE is a legal issue, AOE is a medical issue. If you don't have the medical issue of causation, AOE, or if that's insufficient, you can't go to court and prevail on your affirmative defense.
So we got about 25 minutes,
Right.
24
We need to
minutes
scoot
left.
through.
So let's just scoot through the rest.
I want to interrupt real quick. There's a chat, a question or statement in the chat. I wanted to know if you want me to hold it to
No,
the
let's do it
end,
now.
or if we should do it now since you know what it's about. So Jason says, but for a ROLDA analysis to be substantial per the case law, wouldn't the issue have to go back to the PQME for the issues that would not be addressed by the WCJ?
All the PQME can tell us is what the percentage breakdown is. That's all they can really do. It's up to the trial judge to handle all the factual issues. So it's a dual analysis, and it doesn't look like it was done here.
I think what we said earlier was that the applicant has a burden of proof, which means you got to go to a QME. You got to get that medical diagnosis. You got to get the causation of injury under ROLDA. And then you go to court and you fight over the facts.
Well, if it's 32.3H, the doctor has to say what percentage of the actual events of employment, as opposed to perception, are good faith, non-discriminatory personnel. The non-discriminatory personnel action is litigable. All right. So it's kind of a dual, physician, dual trier of fact issue.
All right, let's move on to the next one. The Collado versus California Department of Corrections. Applicant seeks reconsideration of the findings on order issued by the WCJ. WCJ found in relevant part that applicant failed to prove that he sustained an industrial cause injury during his employment, with ultimately the applicant getting a take nothing. Applicant contains in substance the WCJ incorrectly applied the law with respect to whether or not the applicant sustained a new injury, and did not distinguish whether the injury was an exacerbation of the old. So old hat again. So we're sending it back for remand. Applicant filed an application for adjudication, a claim claiming that while employed by the defendant as a correctional officer, he sustained a cumulative trauma injury to his heart and cardiovascular system in the form of hypertension. He previously obtained multiple awards from the defendant. We don't need to get too into the weeds on that one. Panel QME evaluated the applicant for his claim for the heart and hypertension. The doctor subsequently issued several supplemental reports. In the initial report, the QME opined that applicant's hypertension was a continuation of a previous injury with cumulative involvement since 2005 up to retirement. Okay, so that sounds inherently contradictory in nature. In a supplemental report, the QME opined that the hypertension resulted in hypertensive heart disease dating from 2013, which is the first mention of left ventricular hypertrophy. That condition would be attributed to the hypertension, but the hypertension was just cumulative since 2005, and the heart involvement as a result of hypertension, which is cumulative since 2013. But the first diagnosis of left ventricular hypertrophy persisted to a current date. What is important to realize is that hypertension by itself doesn't result in cardiac impairment. However, when hypertension leads to LVH, as in this case, evidence of hypertensive heart disease, as best as I can determine, has been diagnosed with an echocardiogram in 2013. In the final supplemental report, the QMA opined that applicant was diagnosed with hypertension in 2005 per the AME report. Dr. Levister's report indicated that the hypertension was diagnosed in 2005 by a physician at the correctional facility. It is my medical opinion that the period of hypertension dates from 2005 up and continuing up until the time of my report. Therefore, it's my medical opinion that my findings in my letter are applicable and referable. So that got you to a take nothing. I don't know why. Problem sometimes arises when an employee has an industrial accident causing or precipitating a particular condition and thereafter sustained another strain on the job. If the subsequent strain indeed aggravates and worsens that original condition, then it may be considered a new injury to the extent of the aggravation or worsening. However, if the subsequent strain does not rise to the dignity of an aggravating injury, but rather is a mere exacerbation or reoccurrence in the original injury, then no new industrial injury has occurred. Another important distinction between aggravation and exacerbation is that if a second incident causes disability, it is by definition an aggravation. That is because an aggravation causes the temporary or permanent disability, while an exacerbation does not. Thus, if a second injury causes no additional TD or PD, it is mere exacerbation. In the instant case, the QME's opinion regarding whether or not the applicant's current claim is an exacerbation or aggravation is unclear. Here, the QME must answer the question whether applicant's current heart hypertension condition is an aggravation, thus a new injury or an exacerbation. That is, there must be a clear discussion of whether or not there's new impairment or increased need for medical treatment. So what we're talking about here is that if, in fact, there's a new injury that's causing a need for either temporary disability or new permanent disability, then it's a new injury. If there's simply no need for any new TD or new PD or new need for medical treatment, and it's exacerbation. So, guys, we've covered this already. Did we need to?
I want to say anything. I want to say one thing here. The doctor blew it because table 4-2 in the AMA guides, this injured worker went clearly from a class 2 to a class 3 impairment because it became heart trouble when the left ventricular hypertrophy occurred. LVH is actually in a class 3. It is not in a class 2. So automatically, this guy has a much higher disability.
Yeah, he got worse. I mean, this is not an exacerbation.
No, it's a new injury.
Let me run over to temporary disability because we got 20 minutes left. Lopez versus Premier AG Management. Applicant seeks reconsideration of the findings of order issued on October 3rd, 2022, where the WCJ found in pertinent part the applicant sustained injury to his left eye. Applicant was entitled to temporary or permanent disability benefits. Defendant had paid the 104 weeks. Applicant is not entitled to additional temporary disability. Applicant's eye injury was not a high velocity eye injury, so that's an exception to the rule. Boy, oh boy, oh boy, this is not a this is not fun.
This case wins the dumbest case of the year award by the appeals board.
This is a lot of fun. This case was a lot of fun.
This is the dumbest decision I've ever seen. By the
well, let's get through it first before we say it's dumb. Applicant contends the evidence doesn't support the findings of fact because the findings omit the fact that applicant was struck in the eye by a branch that was on a moving vehicle and that the branch was traveling at motor vehicle speed when it struck applicant. Applicant further contends the mechanism of injury as well as damage to applicant's eye caused the injury, supporting finding the injury was high velocity eye injury. So they're going to return it back to assess whether or not it's a high velocity eye injury. Applicant was employed as a farm worker serving on the vineyard cleaning crew. He sustained specific injury to his left eye and his optic nerve when he was hit in the eye by a vine branch while removing wood posts from vine rows and loading them onto a trailer. Applicant first evaluated by ophthalmologist. So this is where we start getting in the weeds, no pun intended. And in the QME report, the applicant was injured when he was walking next to a trailer while simultaneously placing wooden posts in the trailer. As he was doing this, a branch from one of the vines struck his left eye, causing extreme pain, according to the patient, a loss of consciousness. In the F&O, the WCJ denied the exception to the temporary disability rule and limited to the 104 weeks. In the opinion on decision, it said, the injury to the applicant's left eye occurred while applicant was walking next to a trailer, putting wooden posts in the trailer. A branch from one of the vines was held up by the post, striking applicant's eye. So the problem here has to do with, is this or is this not a high velocity eye injury? And we get factually just incredibly detailed, granular about this. Whether or not the injury is a high velocity eye injury focuses on the speed applicant was walking. It appears, however, that under the circumstances of this case, neither the speed applicant was walking nor the speed the vehicle next to him were the required inquiries. Rather, the velocity of the branch that struck applicant's eye must be considered. Here, the branch that hit applicant's eye may have hit him gently as the vehicle drove by him and may have caught on something and whipped back. Moreover, to the extent the applicant alleges a disability result of high velocity eye injury, there's no substantial discussion of the medical record. Medical reporting must address whether the severity of the injury necessarily supports a conclusion that the injury was a high velocity eye injury. Therefore, it's going to be remanded back to have an even more factual analysis. So Judge Rest, it comes down to, did he walk into the branch or did the branch walk into him?
You know, I take it from somebody, full disclosure, I'm totally blind in my left eye from birth. And so this case really pissed me off. And the reason it did is because it wouldn't be this serious of an injury for this poor guy who's still not MMI after 104 weeks. That's what the doctor says here. And I think that any kind of almost enucleation of this guy's eye is a high velocity eye injury. And for the board to say it is a medical issue and not a legal issue, also it adds another layer of unnecessary
I
litigation.
mean, Frank, do we really have to go through this granular detail?
The code says that you do.
I mean, there are people outside the work comp community who think reading something like this is crazy.
This is like obscenity. You know it when you see it, right?
But listen, for 4656, 240-week exception to occur, you have to have any one of the 9 elements, right? If you have hepatitis A, it doesn't qualify. If you have hepatitis B, it does, right? So if you don't have a high velocity eye injury, but you have something that happened to lose the sight in the eye, it's not a high velocity eye injury. And I think that's why this case.
I mean, this case feels like the guy who walked into a hurricane.
Well, he walked into a door. Okay, so
Did he walk? Did he run?
He walked into my fist. That's it.
So need for further medical treatment. Oh my God. Let's get through the UR fund. All right. The Rodriguez case. All right. Oh boy. Petition concerns the jurisdiction of the WCAB to resolve disputes over medical necessity determinations when a worker requires a particular treatment for an extended period of time. Legislative reforms were enacted to ensure that when disputes arise over requested medical treatment, it should be made by medical necessities, not like dumb people like judges. We conclude there's no exception to the statutorily mandated dispute resolution procedure. We reject Patterson to the extent that it sets forth a contrary rule for injuries or medical necessity arising after the 2013 reforms. When a request for authorization is submitted and where there's a dispute over whether or not the request for treatment is medically necessary, that dispute must be resolved through the UR and IMR process and not through this change in circumstances type analysis. So the facts of this case, Orlando Rodriguez sustained significant head and brain injury while working as a mechanic. The employer's insured ProCentury admitted that applicant's injuries were industrial. Applicant's primary treating physician began requesting that Rodriguez receive home health care services in 6-week implements. Illinois Midwest approved some of them and then ultimately ended up denying furthermore that was being requested. And the issue here really came down to whether or not there was applying Patterson, whether or not there's a change of circumstances which would mandate endless treatment or not. Rodriguez challenged the utilization review denial by seeking expedited hearing. WCJ found that Rodriguez was entitled to ongoing home health care. Judge concluded that because the evidence established that he had ongoing and constant need for medical treatment in the form of home health care, Illinois Midwest couldn't terminate the treatment without a showing of substantial medical evidence showing a substantial change. Utilization review, even though his utilization review was timely, it's moot and relied on Patterson. So the language of 4610.5 is unambiguous and applies to his case specifically. If there is that where there is a timely utilization review denial, independent medical review is the only means of review of appeal, and the WCJ didn't have jurisdiction over it. Applying Patterson leads to this illogical situation where we can have separate tracks where you can have ongoing medical treatment that is completely immune from the utilization review and IMR process, and then you have those that don't. So on this basis, both the judge and the appeals board exercise jurisdiction over the parties' dispute. Respondents take the same position. Patterson is misplaced. It's distinguishable in this case. Further, to the extent Patterson announced a general exception to utilization review, we reject. With respect to WCAB's jurisdiction review, adverse medical necessity determinations, Patterson concerned a scenario that is entirely distinct. Remember, Patterson had to do with nurse case managers, not more granular types of care.
In a panel, right?
Yeah. Under respondent's theory, the WCAB would have jurisdiction to determine pretty much any modality of treatment, so long as you just sort of put it into that sort of he needs it, he absolutely needs it. There's no statutory authority to back that up. Moreover, the appeals board's ongoing or continuing care exception opens the doors to a large number of cases involving medical necessity, defeating the legislature's expressed goal of eliminating cumbersome, lengthy, and potentially costly reforms. In the National Cement Company versus WCAB Rebuttal case, that was my case when I was a judge. They denied writ review on it, but said that doesn't really count. Summary denial of a petition for judicial review, decides no issues, and has no presidential value. Well, thanks a lot. The appeals board incorrectly characterized the case summary of Revota as the decision of this appeals court upholding the appeals board application. Actually, it doesn't. The WCAD didn't have jurisdiction. His remedy was to file through IMR in this case. So, Judge Rass, we got about 21 minutes, so we're kind of grinding through this as quickly as we can. It's currently up at the Supreme Court on this one. It's a bad decision all day long on this one.
Yes.
I mean, where do you think the Supreme Court's going to come down on this one?
I think it's a statutory construction case. If you look at 4610.5, I don't know when the last time everybody read that section. It's very cumbersome to read it. But they actually use the terminology in that section as a change in condition. They don't use the terminology change in circumstances. So let's talk about that. What's the statutory reason for the use of the word change in conditions? And I think that, the Supreme Court is either going to come down and say, what don't you understand about the requirement to put in an RFA every 45 days and have it go through UR and the IMR process? That's what the Court of Appeal said here. I think it's a deeper analysis than that. The Supreme Court is the reason they took this case is because of Rebuttal and having the Court of Appeal Rodriguez case being inconsistent with each other.
So, Frank, I mean, I'm still sort of harping on Rebuttal because in that situation, we don't want injured workers getting thrown out of a long-term care facility based on a timely UR that says there's no change in condition. So I understand where Rodriguez was coming from on this one, but how do you defend the right of an insurance company to forcibly remove an injured worker from a long-term care facility based on a timely UR?
That's a really tough issue and a tough question, because those of us on the defense side who handle these catastrophic type cases know that there are a myriad of reasons why, homelessness being one.
And some of them end up getting kicked to the curb.
Why, you have a minor issue happening like a concussion that 3 years later results in a request for institutionalized care, where you don't have the kind of medical facts that would justify that kind of care, and yet you have these procedures that give the board complete jurisdiction, not under 4610 or 4610.5, to make these kinds of determinations. So the Supreme Court really has a very difficult determination regarding a change of circumstance versus a change of condition versus a change of diagnosis. And I think it's a good thing for the doctors to weigh in every 45 days to let everyone know, not just the insurance company, but the applicant's attorney, what is the current condition? How is that current condition amenable to treatment? How is it changing if it is? So that's going to be very interesting to hear what the Supreme Court is going to do.
I'd look at it more in terms of they need to craft some exception to imminent harm. That's where I sort of come down.
Well, that's maybe a legislative issue.
If we have a situation where if you kick him out of the facility, he's going to be homeless, he's going to die. If you don't have transportation services for the injured worker, he's not going to get to his medical appointments, he's going to die.
If those are treatment issues, then the doctor should weigh in. If those things are going to happen and the applicant has some exigent circumstance that may be a compensable consequence of the injury, then the doctors need to report.
Well, you know what applicant attorneys say, everything's an exigent circumstance.
Well, of course, that's why you need doctors reporting. So if this case stands for the proposition that we need to waive the doctors weighing in every 45 days, I'm not for that.
Yeah. Trial procedure. We got about 8 minutes.
Yeah.
Fusco.
Oh,
Another on-bank decision.
this could be an easy.
Let's just get through this one. Applicant seeks reconsideration. This is James Finette's case. Applicant seeks reconsideration of the findings and order issued by the WCJ. WCJ found in pertinent part that in response to applicant's discovery request, the defendant is only required to comply with Rule 10390 and disclose the name of the employer's workers' compensation insurance carrier. Applicant contends the WCJ conclusion only requires the defendant to disclose the name of its insurance company is too narrow, and that on-bank decisions such as Cold Iron 1 and 2 require additional disclosures, including disclosure of high self-insured retention, a large deductible, or any other provision that affects the identity of the liability. So based on the review, they basically had a 3-point response, which is, of course, Cold Iron is still good law. The appeals board is statutory that authorized the issue regulations, and that Rule 10390 doesn't supersede Cold Iron. So it's going to get remanded back to clear this up. So the applicant sustained injury to various body parts while employed as a massage therapist. So the insurance company just wasn't paying the bills, and it was driving the applicant's attorney up the wall. So he requested, I want to know who your excess carrier is. I want to know who's paying for all the medical treatment because you guys aren't paying for anything. So the defense attorney basically said, go pound sand. Your request for the above information appears to be applicable to personal injury cases, so have fun. We're going to give you nothing. There's no legal authority requiring us to disclose the policy limits, the primary and secondary excess carrier, the limits of the carrier's policy, or any stakeholder with actual potential financial liability. The issue proceeded to trial on this one. ultimately, the WCJ found applicant has no showing that employer's compensation insurance group at the risk of default and beyond the disclosure of as the carrier is warranted by any legitimate litigation or benefits purposes. The facts of the current case provide an example of why cold iron disclosure requirements are essential to accomplish our constitutional mandate to achieve substantial justice. Here, an award issued, but the medical expenses for the injured worker required when unpaid, although the reason for the payment problems is not entirely clear. There can be no doubt that applicants entitled to the information about which entity or entities are liable for payment. The burden to ascertain the identity of the entity liable for payment cannot be placed on the injured worker, the information more readily available to the defendant. These disclosure requirements serve to protect all parties, knowing the identity of each defendant assists applicants in determining whether to resolve this case, their case, or whether or not to ensure a smoother adjudicatory process. Defendants are required by the labor code to pay all compensation. If a dispute arises, we need to identify who actually is the payor. Thus, it serves the defendant's interest to comply with these disclosure requirements to ensure they're not held liable for payments and should not be their responsibility nor sanctioned for conduct. The disclosure further serves all parties' interest by facilitating more expeditious proceeding, by ensuring that each matter is resolved in a way that accomplishes fundamental fairness. So it's basically, there's no right to privacy issue here. It's a routine discovery request, and it's a straightforward application of the principle the parties are entitled to further discovery. Rescind, remand, and if the defendant fails to do so, applicant may seek sanctions, which is probably what's going to end up happening here.
This is what I call cold iron on steroids. And it creates almost like the right for the applicant to do a series of interrogatories to the defense, which is totally illegal. It just relates back to the Allison versus WCAB and Hardesty cases, which create discovery in workers' comp. And you know, the issue before the judges in discussing this with Chief Judge Levy is whether or not applicants' attorneys can file a petition to join some of these excess carriers and, you know, determine whether there's a high retention policy and so forth. I don't think so. I don't think that's something that is that discoverable.
So we got about 4 minutes left, so let me try to get through the rest of this. Pirowski versus WCAB in this case, another situation where I guess the appeals board didn't get it right. The question presented in this case is whether the decision that the applicant's stroke did or did not arise within the course and scope of his employment based on substantial medical evidence. The record reveals that medical evaluators are not provided with witness statements more contemporaneous with the stroke or incapacitated with the testimony because a Pirowski is incapacitated, can't recount the events. We had to go off of forensic information, so witness testimony, witness statements, various things like that. The problem in this case is that there was conflicting information. So the applicant had a stroke. He was deemed incompetent, so he couldn't testify. His wife was appointed guardian ad litem. So the factual conflicts came from the employer witness statements, testimony. Basically, it came down to, did you call 911 5 to 7 minutes later, or was it 30 minutes later? In this case, the conflicting testimony seemed to be either was it 5 to 10 minutes, or was it 3 hours later? And so when the paramedics arrived, Acosta stated the applicant was unable to speak. So Paul Groden, the QME in this case, noted there was pre-existing hypertension. So the predominant causation was non-industrial, and it came down to his assessment that it really had to do with the time lapse in terms of how long it took the paramedics to actually get to the location. Dr. Groden deferred his final opinion to review the coworker's testimony or statements if available. According to one of the coworkers, there was a 2-hour delay. The applicant's severe complications arose from approximately 2-hour delay in calling the paramedics. The question is, was it 5 minutes, or was it 3 hours, or was it 2 hours? However, if the paramedics were called immediately, then the spontaneous occurrence caused by the pre-existing would have been considered non-industrial. So the problem here is that Dr. Groden couldn't render a proper opinion until he actually had access to the witness statements, and that wasn't made available to him, and the judge just simply went ahead and went off of the witness testimony. So the question is whether or not there was a delay in treatment. So that's really the core issue here. So the problem was Dr. Groden's opinion was based upon insufficient information to determine whether the stroke was caused by employment, whether or not there was a delay in medical aid with the resulting disability. In part, as the first opinion, Dr. Groden expressly requested witness statements, which were not provided to him. Dr. Groden opined without reviewing any witness testimony, even though it provided a trial, that if the paramedics were called immediately, there would be no industrial injury, but if there was a time lag, there would have been, and ordered the board to develop the record. We're hitting 9:29, so we're going to run slightly over, but we're almost done. the Radar versus Ticketmaster case. So this is slightly interesting on this one. So the issue here had to do with a commutation. Hold on. Applicant sustained. So WCA found in this case, the WCA lacked jurisdiction to amend the applicant's prior award of permanent disability, and that applicant did not prove an additional indemnity. So basically what happened here was that there was a commutation for attorney fees that required taking it off the side of the award. And what happened was that the applicant lived long enough so that the entire attorney fee had been completely paid out. And though the question comes down to, does the insurance company get to continue reducing biweekly payments, even though the attorney fees have all been paid out? And Adam Graff on this one did the exceptional job of getting it wrong and saying, well, that's the benefit of getting your money early on this one. Applicant contends the amount commuted from his permanent disability award had been fully satisfied. WCJ's report acknowledges that a certain level of imprecision is inherent in any estimate of life expectancies, but that the gross amount of the weekly reductions has now exceeded the amount paid out. But this is okay, but this is what's supposed to happen. One of the two parties inevitably ended up at the financial wrong side of the estimate. Luckily for applicant in this case, he means he's beaten his projected life expectancy. Well, good for you. You actually lived longer than we had expected, but we're going to still keep taking money out to give to the insurance company. So in this case, they ended up saying, we believe a commutation that provides for an indefinite reduction of the benefits paid to the permanent disability is incompatible with the mandate of Section 5100. So there was a recon to the recon on this one. I want to quickly just go through, because the defendant makes some valid arguments here, saying, well, if the applicant died early, then we would be out. So that doesn't seem fair. In this case, they're going to uphold their decision. So defendant also, they also made an argument that that the appeals board cannot alter an award on this case, saying that we're essentially rewriting the decision-making on this case. Defendant also asserts our jurisdiction has held that an individual's applicant life expectancy cannot be considered in commutations of applicant's attorney fees, that our decision is contrary to public policy. Applicant's answer distinguishes between the commutation of attorney fees over the entirety of the applicant's lifetime and a commutation of a fixed sum originally calculated based on his life expectancy. Because the decision of WCA represents a simple calculation of the date of life expectancy, the end of the reduction does not constitute a revision of the award. So what it really comes down to is we're not rewriting the award, we're just simply altering its payment structure and its payout on this one. That is, there's no statutory basis to continue to allow an amount against lien against compensation if the lien has been satisfied and liability for it has been extinguished. That is, when a lien has been paid, liability for it no longer exists. So they keep arguing that we don't have jurisdiction to alter the award, but we clearly do in this case. Let me just get to the end of this. So consideration of applicant standard life expectancy played two roles. The present value of the anticipated award over applicant's scheduled life expectancy was used to determine the projected value of applicant's lifetime of the permanent total disability indemnity payments would yield $262,964.75. In this case, it was a 15% attorney fee. We're continuing to question whether the settlement would remain fundamentally adequate were defendant allowed to continue to impose reduction on indemnity payments well beyond the attorney fees provided for in this case. So Frank, let's just quickly sort of address the issue on this one. I mean, does it bother you at all that if the applicant dies early, that the defendant doesn't get a windfall, but if the applicant lives long enough, that the insurance company should bear a negative burden?
This is a rough circumstance. When you make an award, whether the applicant has cancer or not, if the applicant dies and the attorney fee is paid from benefits the applicant is awarded on, the day 6 months later he's dead, the insurance company or the payor is never going to recover the value of the.
I mean, it's a one-sided system anyway.
It's a one-sided system.
It's saying, well, what's good for the goose is good for the gander.
So with this case, basically, if years later, the defendant gets a request by an applicant's attorney to increase the award as opposed to litigating and as opposed to 5814.5 attorney's fees, increase it by a few dollars a week.
Look, I mean, I had an applicant.
I think that's what's happening.
I had an applicant in pro per. He had permanent total disability. He had multiple commutations. And by the time we got to the end of it, there was no more money to commute.
Yes.
So he complained to me, well, what am I supposed to do to get more money? And I said, live forever.
The applicant pays the attorney fee. That's what the commutation is all about. So the applicant pays the attorney fee out of the benefit. The fact that the attorney fee is commuted to a lump sum, it's still the applicant's benefit that's being reduced over the course of time.
So let's get to the Hernandez versus Riverside landscape case. So lien claimants, we're almost done here. Lien claimants, RMS Medical Group and Basso Pharmacy seek recon of this case. WCJ found a pertinent part that applicant, while employed during the period June 5th, 2012 to 2013 as a laborer, sustained industrial injury to his back, lower extremities, and psych, that RMS Medical Group and BAP are not entitled to recover anything with regard to their lien. Lien claimant contends the WCJ erred in finding the lien is not required any further payment. Lien claimant argues the medical group was designated as PTP and that PTP, lien claimant was required to make medical legal reports, and the existence of an AME does not relieve the PTP of its reporting requirements. Lien claimant also argues the defendant should pay per service and that they're not entitled to credit against the entire billing for any overpayment made. Applicant claimed injury to his back, lower extremities, and psych. Elected Guy Galchuk as the primary treating physician and asked him to perform initial evaluation, medical legal evaluation with various issues he had to address. And the question really just comes down to, is he entitled to medical legal reimbursement on this one? And the answer, of course, is yes. Based on the history and examination, he found it was industrial. On January 18th, 2023, liens of the RMS Medical Group in Basso came on for trial. FNA said basically they don't get paid because they didn't provide any medical legal services. Well, that's just wrong. The appeals board has previously held there's no legal authority to support the proposition that an injured worker is not entitled to request a medical legal report from the PTP, and in turn, the report from the PTP is a medical legal expense for where the defendant is liable. That's just not true. PTPs can provide medical legal services and are entitled to medical legal reimbursement. So this issue happens all the time. You know, applicant treats the injured worker, gets to take nothing, comes down to court and says, at least pay us for our first report. No, I hate you, I'm not going to pay you any money. Lien claimants are terrible people, so therefore I'm going to pay you nothing. Here, applicant's attorney issued a letter requesting a medical legal report from a PTP. PTPs can opine on medical legal issues. It proves or disproves a disputed issue here. Furthermore, it's reasonable for applicant attorney to request a medical legal report. As such, they are entitled to reimbursement. Frank, this issue comes up a lot where it's like, you know, are they entitled to medical legal services if the PTP is just grinding out useless medical reporting in your estimation?
Well, you can't get a med legal within 60 days. That's what the code says. But a PTP, as you happily point out, can issue an opinion to help the applicant prove an AOE.
I hear defendants making this argument to me all the time. Well, Judge, what do we need a QME for then?
That's why we're talking about this case.
There we go. So we're done.
Thank you, everybody.
Thank you, everybody.
Do we have any residual Q&As?
So when you guys were addressing that one question earlier, Jason came back and said PQ, and this is about the ROLDA analysis.
Yeah.
PQME would need to address if the lawful, non-discriminatory, good faith personnel actions substantially caused the DSM diagnosis, ?
Yes.
Yes, it's an actual event of employment. And
Absolutely, yes.
The doctor has to define what the injury is, and then the applicant has to prove that there's disability directly caused by the injury. So you have elements of affirmative defenses and medical issues.
Yeah, the judges have to follow the ROLDA analysis, and if there's not enough medical evidence of it, they have to reopen discovery and send the parties back.
Right.
The doctor just has to tell us what the percentages are. What is the percentage of what are the events that occur? Well, but actual events is a judicial determination. Yeah. The applicant's going to complain about
in the DSM, Doc.
No, just provide us a factual analysis. What is causing this person's issue? Does this person have, I was upset because they were rude to me. Well, let's break it down in terms of each employment event. And then you leave it up to the judge to figure out which of those events that are causing the psychiatric injury, which ones are actual events and which ones are completely bogus, made up manifestations of this person's inner mind. And then of those actual events, you break down even further. Which ones are good faith personnel actions, which are decisions made by the employer in order to manage and control their employees, versus something that isn't a good faith personnel action, which is we're doing that where you're either being harassed on the job or you're being persecuted. What's interesting about that factual case that we discussed is that it's easy to get bottlenecked into the, okay, he's a transgender individual and he's wearing a dress and he's being harassed. Well, that's one way to frame the story. The defendants are going to look at it in a slightly different way, which is we have business attire requirements that we apply to everyone. We're talking about an individual who is required, along with everyone else, to wear pants, a shirt, and a necktie. And if this individual has some medical issue or has a note from his doctor, then the issue would have been much more interesting. But what was occurring here is that from what it seemed like, because I could see it, I could see the narrative going in a different direction. Simply telling an injured worker, an employee, you stop wearing a dress to the office. You need to wear pants and a suit and everything else. And we do that with everyone else. That could be construed as a good faith personnel action. Now, I would think in this situation, if this guy just simply comes in with a medical note that says this individual is going through some form of transition and therefore he should be allowed to wear, then it becomes an Americans with Disabilities Act type situation.
I think it should have done that in the first place.
I mean, that's how I would have looked at it. I mean, it's just an odd set of facts that are here, but it could have been avoided in a much more easier way. I mean, Frank, this issue, I think, does come up with employers because they're in a situation like this, they're going to call you up and say, look, we got a guy showing up to the office wearing a dress. We've got rules that say you need to, if you're a guy, you've got to wear pants, a suit, and a necktie. And if you're a woman, and this guy hasn't given us any notes from a doctor or any accommodation requests.
You shouldn't have to do that. I'm sorry, but you shouldn't have
And you get a handbook of rules and regulations and notices when you onboard. And onboarding is a very intensive issue now, right? So if the applicant said, I just need the job, I'm going to live my truth no matter what they say, and he comes in and all of a sudden within the first, few days, he's violating the handbook. And they're gently trying to tell him, look, these are the rules. These are the regulations. You want to live your truth, live it differently outside of work, right?
So what do you tell the employer? Because you got an employer saying that he's telling me I'm discriminating against him. So am I just supposed to let this guy show up in a dress?
And then you go to trial if you're a defendant.
I would let him show up with the dress. I would keep my mouth shut. I would tell the supervisors to keep their mouths shut.
I mean, Frank, is that how you would advise?
Well, listen,
Just stay away from it.
every business has its rules and regulations and internal processes, right? And that's what makes America great. If you want to, it's called freedom. So everybody's got freedom. We're weighing the freedom of the employer to have, workplace rules versus an employee saying, I'm at will, but I'm going to do my thing, right? So where's that balance in terms of a psychiatric injury and post-termination?
I mean, I've known of cases with the state where you have an employee who shows up wearing pajamas. They wear a onesie. So that was what was going on. So the employee shows up wearing one of these onesies. Basically, it's what they wear when they go to sleep.
Right.
And so, okay, well, you can't wear a onesie to the office. Her argument was, I'm very petite, I'm very obese, I can't just sit at a desk all day and work, and I can't have anything cinching my waist.
If it's not in the handbook and there's no prohibition, great. It's called freedom, right? And there are some employment circumstances where that's allowed, right? So every employer is different. If you go to the Superior Court, you're not going to be able to live your truth in Superior Court, where you're going to be in a courthouse and you're going to be exposed, to folks. But if you are in an art shop or in a music studio, that's a different employment situation, right? So just like fingerprints exist, every employment handbook, every employment circumstance is different.
But we're kind of dancing around the issue. What would you tell the employer in that case? Just let him wear a dress, like Judge Rasmus?
Like I said, I'm gonna dodge your question. I'm gonna dodge your
I
question.
love this case, and it's going to be one of my final exam questions.
I like it. That's right. It's a there are a lot of factors, a lot of elements in what the employment expectations are, whether those expectations were explained, and whether someone willfully violated employment expectation rules.
I mean, we're assuming this individual is transgender in nature, but it could also be just some troublemaker in the office.
Well, we're assuming based on what we read. But what we read is not necessarily, the truthful story.
Well, what did the doctor say in this case? The doctor was practicing law without a license. That's basically what happened here. That's what my notes say.
But it's an interesting case, and it's a lesson for you as a defendant. If you're going to be proving 3208.3H, and you've got elements of discrimination, you've got to make a good record.
Well,
You've
but Judge
got to
Rest,
make sure.
let me ask it this way. If the so-called harassment is nothing more than just emails from HR, you are to adhere to our non-discriminatory tire process.
I think it violates the civil rights.
That's right. Well, but that's a different forum.
That's what I've been saying all
That's a
along.
different forum. So at the board, it's a good faith personnel action defense.
But wouldn't it just be easier if you just simply had a medical note from a doctor?
Then it becomes an ADA issue.
Yeah.
And an ADA reasonable accommodation requirement would be filled into that. What does that have to do with being a
I mean, it sounds like from the employer's standpoint, it's like we should just not even get into this thing because we're going to get sued no matter what.
That's right. That's why
And as an employment attorney, I would just say, look, you're just going to step on landmines.
well, that's what I would tell the employers.
If you think that this guy is just playing games, unless you can show that this guy is truly disrupting the work environment, just let him wear whatever he wants.
Well, see, the reason this case exists is because someone felt that there was a disruption in the work environment.
They wanted to get rid of it. Period.
Okay, gentlemen, it's a quarter after the time we're supposed to conclude.
I was going to say, Yvonne, are there any other questions before we go?
I don't see any other questions. I've asked twice, and so I think it's a good time for us to stop. Good discussion, so thank you.
All right.
Thank you.
I do want to say thank you to the folks that joined us today for this preview of what is to come on Saturday, June 6th. And that is when we will have our full 5-hour with a break. We'll have a half an hour break in the middle. And we are also talking, the panelists and I are talking about bringing this to you live in person at the Elevate conference in September. So more news to come about that very soon. So with that, you guys stay put. I'm going to pause the recording and say goodbye and thank everybody once again for showing up on a Saturday to talk about these really interesting cases.